This is a story about a woman we'll call Mary Johnson. She's asked us not to use her real name because she's involved in a legal battle that will likely leave you shaking your head. Several years ago, Mary went to the doctor. She was billed $294 for the visit, but says she never got a bill and quickly forgot about the trip. That bill ended up at Medical Recovery Services, a debt collection company based in Idaho Falls. Attorneys Brian Smith and Brian Zollinger handle cases for the company. Fast forward to early last year. Mary works at Melaleuca, and Medical Recovery Services sent a garnishment notice to her employer, requesting nearly $1,000 for the $294 bill. The additional money was for interest and attorney's fees. But there was one problem.
Melaleuca received a garnishment document that didn't match any name of an employee, and Melaleuca couldn't guess, and potentially guess wrongly, as to who the true judgment debtor was.
The Social Security number on the garnishment was Mary's, but the last name did not match hers. Melaleuca's proposal to Smith was simple: send us a legal request called an interrogatory asking us to tell you the name of the employee with the Social Security number. But Smith refused, and 1 month later, he and Melaleuca attorneys went before Magistrate Judge Michelle Mallard. They got to the bottom of it. Judge Mallard ruled that Melaleuca's response to the garnishment was true and sufficient. She discharged the company of any liability and told Smith that he could ask Melaleuca to tell him the name of the employee, something the wellness company had already offered to do. Court documents show Smith sent an interrogatory, learned the employee's name, garnished her wages, and obtained over $1,200, nearly $1,000 more than the original bill. So case is closed, right? Not so fast. Last month, Smith filed an application for award of supplemental attorney's fees. That's legal talk, meaning he wants someone to pay for the time he spent on Mary's case. The amount he wants? $5,583.25, nearly 20 times more than the original medical bill. And who does he think should pay those fees? Mary Johnson. Of course, we wanted to ask Brian Smith about this. He was too busy for an on-camera interview, but did speak with me on the phone. Why should she have to pay for that?
It's real simple. Under the law, we get to ask the court for what's called post-judgment attorney's fees for the work we had to do after the judgment to satisfy the judgment.
But it's not her fault. All of this was not her fault.
I understand that, but it's not based on fault.
Do you think that your firm did anything wrong in this case?
Absolutely not.
And Smith believes Mary should pay him over $5,500 for the time he says he spent on the case. Now, this is just one of many, many cases that Medical Recovery Services has been involved in over the years. Tomorrow on EastIdahoNews.com, meet a man who was sued by the company over a mistake his doctor made. He fought all the way to the Supreme Court and won. I'm Nate Eaton, EastIdahoNews.com.